Thank you, Your Honor.
Thank you, Your Honor. So I don't have a highly produced video, but I do have a few words that I think this court should follow and think about in this case. The United States is the oldest modern democracy, well over 200 years, far different than any other country in many ways. And what makes us different is the experiment we launched, which is this thing called elections. We have elections. And that means when it comes to decide as to who should lead our nation, it's the people of the United States of America that get to make those decisions. Not 6 voters in Colorado who've picked and chosen who they want to file a lawsuit against. And this court should not interfere with that fundamental value, that rule of democracy. It's the people who get to decide. And this lawsuit seeks to cancel that principle. This lawsuit is anti-democratic. It looks to extinguish the opportunity for millions of Coloradans, Colorado Republicans and unaffiliated voters, to be able to choose and vote for the presidential candidate they want. In fact, the leading Republican presidential candidate. And by many measures, the candidate, most likely to win the presidency. They want to extinguish that opportunity by preventing him from running for office. It is anti-democratic. This is a case of lawfare that seeks to interfere with the presidential election. We argue here that this, at its basest level, this is election interference. The petitioners here, the 6 voters, have appointed themselves private attorney generals. They can pick and choose and file lawsuits against whom they seek to disqualify. And they rely on exceptionally weak and frankly, in some cases, fringe legal and logical theories to try and tilt the playing field of this election by wiping out President Trump's ability to run for election well before anyone has an opportunity to vote. They are asking today for a number of historical firsts. First, they are asking this court to be the first ever in American history, to disqualify a presidential candidate under Section 3 of the 14th Amendment. We've pointed the court, I believe, to, or we will, Horace Greeley, who ran in 1872 as a Democratic presidential candidate. He had paid for Jefferson Thomas's bail. He was loudly accused of giving aid and comfort to the enemies of the United States shortly after the Civil War when he ran. Lots of debate on that issue. No one ever once thought of trying to disqualify him from voting. They took their arguments to the people for them to make that decision. Eugene Debs, Socialist Party USA candidate in 4 elections, in 1920, ran from jail. He had been convicted of sedition for giving aid and comfort to enemies during the First World War by trying to stop military recruitment. He was convicted of that. He ran from jail. He was never disqualified. No attempt was made to disqualify him under Section 3 of the 14th Amendment. The case of Eugene Debs is often regarded as a low point in American history, a low point when it comes to First Amendment protections. And for good reason. People should be able to run for office and shouldn't be punished for their speech. The petitioners asked this court to be the first state court in American history to disqualify a presidential candidate. They are asking for the first time in American history to disqualify any federal candidate, a state court to disqualify any federal candidate. This is the first time in Colorado history anyone's ever tried to disqualify a presidential candidate under the 14th Amendment. Asking the Secretary of State to go back and research a candidate's behavior, that's also a first. Never been asked or demanded before. Even right now, there are about 50 cases either pending or have been nationwide specifically attacking President Trump. This is not a new tactic. This is the first where a dismissal is not automatically, I shouldn't say automatically, but promptly been granted because of the weakness of so many of these arguments. They're asking for the first time that the January 6th report be treated as evidence in this court, in a court of law, that politicized hearing. That's what they're asking, is that this court rely upon that as evidence. And frankly, they're asking this court to be the first in the country ever to embrace a number of legal theories that have never been accepted by a court, state or federal. There's a lot of firsts they're trying in this case. They're legal theories. I mean, we're arguing we shouldn't even be here. And we've argued that multiple times. This is a federal issue, perhaps the most important federal issue we can have. And it's for Congress to set these standards, for Congress to provide guidance, not for the petitioners to come up with theories and try and convince you that they may be right. We've argued the 14th Amendment not self-executing and the preemption and political question, and we understand this court's ruled against us in every instance. But nearly every court that's ever looked at presidential qualifications, and I'm not just talking about issues involving President Trump. Did you hear that loud?
You should just expect this to be regular occurrence.
I live in Denver, Your Honor. I understand sirens, unfortunately.
I really like this courtroom because it's right next to the fence.
So it's not just President Trump. You may recall that there was a little bit of controversy about President Obama's citizenship. And there was some controversy about Senator and presidential candidate McCain's citizenship. And there was controversy about Senator and presidential candidate Cruz's citizenship. And there's one or two instances where those went to trial. But the vast majority of them were properly dismissed. The overwhelming weight of evidence is that this case should not be here. Now, I want to talk a little bit about some of these specific claims. The claim that there was an insurrection. What constitutes an insurrection really needs to be grounded in historical usage. Because if you don't ground it in historical usage, you're just making it up. Now, I'm not accusing the court of making it up. I'm accusing the petitioners of making it up. But look, you will hear from Professor Delahunty that there are lots of definitions of what an insurrection is. It's been going on, that word's been in English usage for a couple hundred years, probably more. I haven't quite looked at the etymology of it. And there are a lot of definitions. Your Honor, I submit I could construct a legal argument or a law review article defending pretty much any one of those definitions. And when there are numerous definitions, that means there's really none. You might as well pick a definition out of the hat. And the petitioners have picked a definition out of the hat that suits them. That's their job. I get it. But frankly, they're making up the standard so that it fits the facts of January 6th. And I'm sure they'll try and come up with an argument that it'll just fit the facts of January 6th and it'll never fit any other facts and there can never be any consequences. But the bottom line is they're making it up and they're picking a definition out of the hat. What constitutes an insurrection needs to be grounded in historical usage because that's what the law demands. That's what equality under the law demands. That's what fairness, so we understand what the standards are by which we comport our behavior. Not post facto making it up to try and figure that out. The term engage. The term engage means to do something. Frankly, no one really knows what that means, but I think we can all agree it means to do something. That's what the word engage means. Okay? There's substantial historical evidence that engage does not mean mere incitement through words. It doesn't mean that. And frankly, President Trump didn't engage. He didn't carry a pitchfork to the Capitol grounds. He didn't lead a charge. He didn't get in a fist fight with legislators. He didn't goad President Biden into going out back and having a fight. He gave a speech in which he asked people to peacefully and patriotically go to the Capitol to protest. Now, I understand that there's several experts that are going to testify, and one's going to testify that President Trump, he just didn't do enough. He should have done more. Now, that's a case of Monday morning quarterbacking, but he's saying, you should have done more. You didn't do enough. Should have done more, should have done more stuff earlier. I can come up with all kinds of theories, this professor will say, as to why you should have done enough stuff. And that professor is no doubt a learned man and very thoughtful on this. But his basic argument when it comes down to it is they're claiming President Trump was negligent. Now, we reject that factual claim, of course. And you'll hear that evidence that that characterization is completely wrong. But more fundamentally, the entire theory is wrong. The failure to do something is the opposite of the word engage. It's the opposite of the word engage. And we've argued engage requires specific intent. Someone doesn't just sort of stumble into starting an insurrection. They have to have the intent to do that. And you'll hear evidence that President Trump took very specific actions to try to prevent violence, to take precautions that he didn't want there to be violence on January 6th. And on January 6th, he called for peace. And he used the word peace at least 4 times in his speech at the Ellipse and 2 tweets and a video message. So he asked for peace. Now, the petitioners have played a couple videos.
Cards are stacked against you, I guess.
I've been here before, Your Honor.
I promise it's going to be an equal opportunity problem.
I'm assuming your clerks are not taking time against me when the sirens go by. Stop that timer, please. So my next point is, thank God we have a First Amendment. I'm very thankful for the First Amendment. Spent most of my career defending the First Amendment. Now, there's a reason it's the first, not the second, not the eighth, as I debate with my friends who like the Second Amendment. It's the First Amendment, and it's free speech. And I referred to Eugene Debs before. Eugene Debs was thrown in jail. He had to run for president from jail because of his speech. And it's properly condemned, that case today. And in fact, even then, his sentence was commuted very shortly after the election of 2020. None of President Trump's speech ever called for violence, just the opposite. None of it ever called for insurrection. Did it call for political pressure? Yeah. Did it use a metaphor to fight in the political context? Yes. And I don't think even the petitioners would allege that President Trump, when he says fight, he wants to get into a fist fight with people. Okay? None of his speech called for the overthrow of government. None of it. Any objective reading, the plain language of his speech, was clearly not directed towards violence. Now, the petitioners are going to have an expert on speech, an expert who says right-wing speech. He understands what right-wing speech, right-wing extremist speech really means. And he's basically going to argue, when you strip away all of the academic language and you look at what he's saying, he's going to say, look, President Trump used a bunch of dog whistles. And of course, a dog whistle is a whistle that has a very high pitch that humans can't hear, but dogs can hear. Okay? And he's going to say, President Trump had this sort of dog whistle. I don't know if he'll use the phrase dog whistle. But he used a speech that really these far right-wing extremists could understand and mobilize on. But us mere mortals, well, we missed it. We didn't understand it, but those folks understood it. He's going to say that normal, sort of commonly used English doesn't count because there's this subjective, special language out there that is sort of underneath it all that has been unearthed by the sociologist. And only right-wing extremists and people very learned in sociology and right-wing extremism can understand. And he's going to say that with his expertise, he's been able to decipher what we normal mortals cannot. And his decipherment is going to basically say that President Trump was really ordering people to be violent. Even when he said peaceful and patriotically, even when he sent out tweets that said be peaceful, that's not really what he meant. And the those right-wingers knew it. He meant something else. This turns our American values on their head. It is fundamentally anti-First Amendment. He is saying that when we look at political speech, we don't look at it in an objective way. We don't look at the plain meaning of the words. We look at this secret, hidden interpretation that no one in this courtroom, or, well, I mean, maybe someone in this courtroom besides him can understand. Maybe he thinks I understand it and no one else can. I will submit I was in Georgia on January 6th helping with an election. But the right wing can understand it, but no one else. That is anti-First Amendment. In fact, that has been soundly rejected by our courts, and properly so. We look at what people say as we commonly understand them. And the common understanding of peacefully and patriotic means don't commit violence and support your country. That's what it means. Let's talk about the history and meaning of Section 3. You're going to hear from two professors. You've gotten about 40,000 words of briefing on sort of the meaning of Section 3. You've rendered an opinion against us. And I understand, that's a conditional opinion. You want more evidence, and you want to hear more argument, and that's what we're providing. And so I'm going to ask you three things, all right? First, I'm going to ask you to reconsider your footnote 5 in your order.
Remind me what that is.
I'm not, Your Honor, because I'm not going to take up the time. But I'm simply going to ask you to reconsider it, okay?
I'll write it down. So
Thank you. And I think those cases deserve a much closer reading, and I respectfully say I believe that they were improperly mischaracterized. Okay? So that's my first request. My second request is, when you look at the experts, and our position, and I think the court ultimately agrees, is that they're testifying as to what the law is and what the history is. And Your Honor rightfully recognized that there's other folks out there. So I'm just going to give you a lineup of the other folks. On one side, the petitioners cite Baud and Paulson and Graber, three professors. Baud, Paulson, and Graber. And on our side, we cite Tillman and Blackman and Lash. And I'd like you to take particular care to look at Lash's, Professor Kurt Lash's articles. And because he's done a more thorough analysis of the history behind the 14th Amendment in Section 3, the congressional debates, and the ratification debates, not just what legislators said, but how it was understood by the public as well. You're going to get an overview of that. You're going to get argument on that. But I'm going to urge you to take a look at those others closely. And third, as we've said, we think this is legal argument and not appropriate for rules of evidence. It's in. The court will make good, will provide its analysis. And we have talked to the petitioners about just frankly including the expert reports, the law professors as demonstrative exhibits to review. That's fine. But I think what you're going to see is when I talked about the lack of firsts, there's a reason presidential candidates have not been knocked off, or no one's even attempted to, under Section 3 of the 14th Amendment. Okay, there's a reason this is a unique case. There's a reason cases like this have either never been brought or quickly rejected. There's reasons for that. And the reasons are grounded in the text and the language of the 14th Amendment. You're going to hear about the Secretary's authority from Ms. Hillary Rudy. This is sort of an interesting case in the sense that my understanding is petitioners are calling Ms. Rudy and haven't even spoken to her. And we haven't even spoken to her. So it's going to be an adventure. But having had some experience in that office, I'm confident you will see that this case is a radical outlier from the Secretary's past practice, in addition, obviously, to the 14th Amendment. Let's talk a little bit about the evidence before the court today, or this next week. To be sure, the petitioners have spent about 10 months preparing their case. As you have described, we've talked about this as a mantra. I'll submit volume does not equal quality. A lot of attorneys does not equal a good argument. A lot of stuff in front of the court does not equal good evidence. The court shouldn't confuse a vigorous effort with a good argument or with good evidence. If anything, the fact that they have to put on so much and make one inference and pile one argument on top of another shows the weakness of their case, not strength. After all the time they have prepared this case, this is what they've got. They've got the January 6th report. They got 2 police officers out of hundreds, perhaps thousands of police officers there. And not commanders, but 2 police officers. And they've got 3 professors. 2 law professors to testify about the law, and the sociologist to testify about the coded language. That's what they've got. And they've got 1 House member. I'm sorry, 1 House member. So that's what they've got. And at the end of the day, the start of the day, this case is frankly about the January 6th report. This is their effort to get a court to endorse the January 6th report. That's what it comes down to. The video montage with overlaid sound that you saw in this opening argument, that's a pretty good production. And the reason it's a good production is because the January 6th committee hired a television producer to produce this stuff for primetime TV. The January 6th report made 411 findings, and petitioners have asked to introduce 408 of them, many of which this court has allowed conditionally and allowed argument against. But this report is poison, and I mean poison very bluntly. It is a one-sided political document of cherry-picked information, no adversarial process, with a preordained conclusion. It omits a number of other arguments. It ignored other witnesses before it. And it ignores other explanations and causes. It has very much. Let me ask you this, Honor, and obviously I'm asking rhetorically. If someone walked into court and said, hey, here's how this court case is going to work. I, on my side, the prosecutor, I'm going to get all kinds of time, years, year and a half, to investigate witnesses, to take statements, to gather evidence, okay? And people who strongly disagree with my viewpoint, they get no time whatsoever. They don't get to interview any witnesses. They don't get to get any evidence. They get none of that, but I get all of it. I get to do all of that. And on top of that, you're not going to hear the case. I'm going to choose my own panel. I'm going to choose my own judges. I'm going to choose my Democrats and a couple of Republicans that agree with me. I get to choose them. And then what I'm going to do is I'm going to hire a television producer, and I'm going to time this for an election, and I'm going to put all that out there. And I want you to render legal opinions based on the quality of that evidence. I think you and everyone else would be rightfully would be repulsed by that process. But that's what the January 6th process was. And you are going to hear from a congressman involved in this just the deficiencies and the problems of that January 6th process. And so what the petitioners are doing is they're trying to shove this January 6th report as evidence for this court. They're asking the court to endorse that process. They're asking the court to endorse that one-sided, poisonous report. There is a reason Democrats, for the large part, love that report and cite it. And there is a reason Republicans, for the most part, hate that report and condemn it. And the reason why is that report is a political document first and foremost. This, however, is a court of law. Like you, we, like the petitioner's attorneys, have spent the majority, perhaps all of our adult working lives, as officers of the court, defending one of the greatest American institutions, one of the greatest world institutions, is fair courts that conduct themselves according to the rule of evidence, that work hard to come with good decisions. That's what we do. That's what courts do. That is not what the January 6th report was. And we should hold ourselves here to a much higher standard than that poisonous January 6th report. We should allow in only real evidence that's subject to cross-exam, is properly authenticated by people who actually have knowledge of that. That's what this court should be about, not importing a bunch of stuff from the January 6th report that really has little, if any, credibility. You'll also hear from 2 police officers, and we want to be very respectful of those police officers. But like any human being, they had a very limited viewpoint on what happened on January 6th. And we're going to ask that you limit the testimony to actually what the officers knew. Not what they guessed at, not what they surmised, but what they knew and what they saw. Their actual experience. And we'll point out that, frankly, I mean, there's a reason these officers are here, and it's because of their intense dislike for President Trump. You're going to hear from a member of the House of Representatives, and we're going to give you a member of the House of Representatives, too. There you have it, Your Honor. And then you're going to hear from 3 experts from the petitioners. 2 are going to testify to what the law is, and then you're going to have the sociologist, whom we've already spoken about. That's it. That's their evidence. At the end of the day, their evidence is a January 6th report. Everything they bring in is part of the January 6th report. I won't say everything, but the vast majority of it. Our evidence. I've refrained from naming witnesses. I'll continue to follow that convention. But you're going to hear that President Trump took very specific precautions to prevent violence on that day, as president. You're going to hear that the organizers of the rally at the Ellipse took precautions to avoid violence or inflammatory rhetoric. You're going to hear that the rally at the Ellipse was peaceful. There was no violence. You didn't have a crowd that was intent on violence before or after President Trump's speech. You're going to see that President Trump's communications on January 6th called for peace. They called for respect of the police. Certainly 2 police officers that were involved in violence, you're going to see that from them. But we also have at least 1 witness who's going to say, look, I saw very, very little. I saw a peaceful crowd. Nearly everyone was peaceful. That's a different perspective. And so it's impossible, we think, to say the mob did this, or the mob did that, the mob, the mob. There are a lot of people with a lot of different actions, a lot of behavior. There was not a mind meld mob that President Trump supposedly mobilized. And then you're going to hear about how the January 6th report was a completely partisan, unreliable document. This case here is about President Trump's right to run for office. That right is the flip side of the coin for people to be able to vote for the candidate of their choice. People can't vote without candidates. Candidates aren't really candidates if people can't vote for them. It's the same side of the coin. And so we've talked about the right for the people of Colorado to vote for someone for office. And that's very closely bound with the right of Donald J. Trump to be able to run for office. And the petitioners seek to deny millions of Coloradans that right, and they seek to deny President Trump his rights. Now, I understand the posture that this is merely a state disqualification case. And it's not. This is a 14th Amendment case, and it's dressed up as a state proceeding. 95% of the evidence is the 14th Amendment. Maybe it's 92%. But the overwhelming majority of the evidence in this case is about the 14th Amendment. And the overwhelming argument is about the 14th Amendment. And the consequences are about the 14th Amendment. And it asks the court to interpret the 14th Amendment. That's what this case is about. If it looks like a duck, and if it walks like a duck, it quacks like a duck, it's a duck. This is a 14th Amendment case. Okay? And so I want to bring, it's a constitutional case. It's sort of what we lawyers dream of being able to litigate. We don't dream in law school of litigating Section 1204 qualifications. We dream of litigating constitutional law. And that's what this is. It's a constitutional case. And so I'm going to bring you to my last point. So I'm old enough and overweight enough to where I've been litigating election law in the state of Colorado for well over 2 decades. And this is the 3rd presidential candidate ballot access case I have litigated. Now, obviously, I'm familiar with the law nationwide. And there is a rule in election law. And that rule is called the rule of democracy. Maybe I'm making it up a little bit, but it's the rule of democracy. And that rule says that when something is close, or when there's a unique and strange argument on the other side, okay, when there's a question or an ambiguity or a stretch, the rule of democracy says we err on the side of letting people vote. That's what the rule says. Now, we've made preemption arguments. We've argued about holding office, that the 14th Amendment applies to holding office so that Congress has the choice to remove a disqualification. We shouldn't short-circuit that. We've made arguments about officer of the United States. We've made arguments about engagement, insurrection, First Amendment, all of that stuff. And to date, the court has either deferred those or oftentimes ruled against us. But what I'm asking this court to do is apply the rule of democracy. When something's close or ambiguous or a stretch or an unusual argument, you don't interpret it as a way to cancel the opportunity for people to choose their representatives. You don't interpret it as a way to cancel the ability of millions of people to be able to vote for the leader of the free world. What you do is you interpret it to allow people to vote. Because there is no doubt that the 6 electors don't like President Trump. And I would submit that maybe their attorneys don't like President Trump. And they're experts. And I know the police officers don't like President Trump. They don't like President Trump. And they have every right to vote against him. But there are millions of people in Colorado and across this country who are inspired by President Trump, who view him as someone who protects their interests and who are going to and is going to create a nation, help build a nation that they want to live in and that they want their children to live in. Millions of people look to him for hope and inspiration. And who are the petitioners to prevent those people from not being able to vote on that? Who are they? Well, we're arguing that they shouldn't be able to stop those votes. That when millions of people are inspired by a candidate, and millions of people may hate that candidate, what we need to do, and what the rule of democracy says, and what makes America great, is we get to vote on that person. We don't stifle it. We don't short-circuit it through a court proceeding. We're confident that that's what the framers thought about when they drafted the 14th Amendment. We're confident that that's historical usage. We're confident that our legal arguments and our evidence are appropriate and carry the day. And part of the reason we're confident is because those arguments and that evidence fits within the long tradition of American democracy and of American law to allow an election to go forward rather than short-circuiting it and engaging in what we would consider anti-democratic behavior. Thank you very much, Your Honor.